Hi, everyone, and welcome to Topics and Decisions in Patent Law. I'm Joe Murphy.
I'm Reza Mollaaghababa.
I'm Reza Sadr.
So we have a really great topic today, and we're going to be discussing the Federal Circuit's decision in Alnylam Pharmaceuticals versus Moderna, which centers on claim construction, meaning that's how a court will decide on the meaning of a specific claim term in patents. And here, the technology is related to lipid nanoparticles used for the delivery of nucleic acids, such as those in the mRNA-based COVID-19 vaccines. So I'm going to discuss the technology a bit. Reza is going to get into the specifics of the claim terms and also the law, and then Reza can discuss the actual decisions themselves. And of course, we'll have a discussion at the end. So just some background. This dispute arose from Alnylam's assertion that Moderna's vaccine, which I show here, infringed U.S. patent numbers 11246, 933, and 11382, 979. Both are owned by Alnylam. Sort of the technical aspect of the case was the interpretation of the term branched out keel as it appears in the asserted patent claims, and whether Moderna's cationic lipid, which we'll get to in a second, used in the vaccine, which is called SM-102, which we'll show, fell within the scope of the claims. So the patents at issue describe biodegradable cationic lipids designed to encapsulate and deliver nucleic acids into cells. And this technology really overcomes two problems currently faced by mRNA constructs, which is first, the mRNA susceptibility to nuclease digestion in plasma. mRNA is not really a very stable molecule as opposed to DNA, which is much more stable. And second, mRNA's limited ability to gain access to the intracellular compartments to be translated into proteins. So this is a vaccine, obviously. So it's an mRNA. It's going to be injected into a patient, get taken up into the cells and the cellular machinery. Lipid nanoparticles are formed from these so-called cationic lipids and are used to facilitate the cellular uptake of the mRNA and protect the nucleic acid from degradation and clearance in the plasmid, and as mentioned, provide intracellular delivery of the relevant of the nucleic acid. And Reza is going to go to the claims in more detail, but generally speaking, the claims require a cationic lipid with two biodegradable hydrophobic tails. I'll bring up a slide here that shows sort of the structure of these cationic lipids. The claim also requires that at least one of the tails includes a branched alkyl group at the alpha position. We'll go through what all that means. So an alkyl group is really a chain of carbon and hydrogen atoms connected by single bonds. And a branched alkyl group is one where instead of a straight chain, at least one carbon atom in the chain is connected to more than two other carbon atoms. So here, the cationic lipid includes several distinct domains, right? We've got this head group here. We've got a central moiety, so-called. And on this particular one, we have two hydrophobic tails, and including a biodegradable group, which you can see is a carboxy group. And each of the biodegradable hydrophobic tails has a formula hydrophobic chain, biodegradable group, and a hydrophobic chain. Now, the terminal hydrophobic chain in this hydrophobic tail, that's the bit of the hydrocarbon on the hydrophobic tail on the right side of the biodegradable group, is a branched alkyl group. And you can see here on the side, it's called R13. And where the branching occurs, it is called the alpha position relative to the biodegradable group, which is shown by the arrows on this slide. So at issue here is the alpha position carbon. Now, this is a slide about branched alkyl groups generally, just to clarify a little bit. And as we can see in the slide, the carbon can be attached to a carbon with one, two, three, or four other carbon atoms. I'm going to bring up this slide with the SM-102, which is the Moderna lipid that they used in the spike vax. And as you can see, I've got the alpha position here circled in red, and there are two carbon atoms, which I've got arrows pointing at each of them. So this is really the accused product. if you will. So the question in this case was how much branching is required? Specifically, does the branched alkyl group in the patent claims require a carbon atom that is connected to at least 3 other carbons, or is it enough to be connected just 2 other carbons, so-called secondary carbons? So I think Reza S. will kind of dig through the claims for us in a bit more detail and also discuss the law in this issue.
Yes, thank you very much, Joe. That was actually very clarifying and related to what we see now here in the representative claim of one of the 2 patents that were asserted. This is claim 18 of the 933 patent. So as you see, it's directed to a cationic lipid comprising a primary group and 2 biodegradable hydrophilic tails, all of which you just demonstrated very well. And the parts that are most relevant have been highlighted in the claim, and some even bolded. At the end, you see it recites that the terminal hydrophobic chain in the biodegradable hydrophobic tail is a branched alkyl. And further says that the biodegradable hydrophobic tail has a formula R12, M1, R12, R13. You just showed it. And in particular, R13 is a branched C10-C20 alkyl. So these are terms, and especially the last part, that were argued in the case. If we go to the next slide. So what's at issue here, what really is the center of the argument, is the idea of claim construction. And the dispute was, what you showed is whether the degree of branching around the alpha position carbon with R13, whether it is towards it branching to 2 other carbon atoms or 3 other. Because Alnylam, of course, wanted the broader construction. Alnylam is the accuser, the plaintiff. They wanted to be read as branching to at least 2 or more, and they argued this is the ordinary scientific meaning. Moderna, on the other hand, the defendant and the accused infringer, argued that the narrower construction must apply here because the patentee has provided definition of the branched alkyl in the patent, which Reza will later specifically refer to. But if we go to the next slide, let's just review briefly the so-called law of claim construction, at least the part that applies here. We are dealing with what is called the doctrine of lexicography, where they say a patentee acts as its own lexicographer. The opinion in particular referred to it in several places, and in particular quoted this excerpt from case law where it says a patentee may choose to be his own lexicographer and use terms in a manner other than their ordinary meaning, like the scientific definition we referred to in the previous slide, as long as the special definition of the term is clearly stated in the patent specification or file history. And the court very much emphasized the whole policy behind this, which is public notice, and what a person of ordinary skill in the art understands from intrinsic or sometimes extrinsic evidence. And that was very much, these things were at play in this case and what determined the outcome. Reza, I now pass it over to you to go into details.
Thanks so much, Reza. So Alnylam sued Moderna in March 2022, accusing Moderna of infringing these patents. In the district court basically held that there was no infringement, and the decision rested on the issue of claim construction, and in particular, what is the meaning of branched alkyl that is used in the claims. The district court referred to the definition that the patentee had provided in the patent specification. And in particular, as shown in this slide, the patentee defined branched alkyl in the following way. Unless otherwise specified, the terms branched alkyl, branch alkenyl, and branch alkenyl refer to alkyl, alkenyl, or alkenyl group in which one carbon atom in the group is bound to at least 3 other carbon atoms. And then it says that it's not a ring atom of a cyclic group. So very specifically, the patentee indicates that the branch alkyl requires this limitation that is bound to at least 3 other carbon atoms, and which of course differs from the broader scientific definition that Moderna was advocating for. And based on this construction, the district court basically held that there was no infringement. The case was appealed to the Federal Circuit on this issue of claim construction. And the arguments were made on both sides, and in particular, Alnylam also referred to various embodiments in the patent specification that deviated from this definition. They were broader. But nonetheless, the Federal Circuit affirmed the district court's decision and indicated that Alnylam will be basically held to the definition that it had provided in the patent specification. And the reasoning was that there were many indicators that the patentee meant this definition to apply. The Federal Circuit, for example, said that the sentence regarding the meaning of the branch alkyl was included in the definitions under as subheading definitions. And it was the branch alkyl was set off in quotation marks, and the sentence used the term refers to, which the Federal Circuit said generally conveys an intent to provide a definition. And also the phrase indicated unless otherwise specified, this is the definition. And the Federal Circuit said that there was no indication that in the patent specification or during prosecution that any other definition would have been intended. And so therefore, all of this resulted in the Federal Circuit basically coming to the conclusion that this definition would hold, and therefore the district court's decision was correct, and there was no infringement. So in a sense, the very specific, narrower definition provided by the patentee carried the day here, and resulted in this finding of non-infringement. So that's really the summary of what has happened in the district court and the Federal Circuit. I just wanted to sort of mention one thing here. Narrow definition basically was not useful to the patentee. But I just wanted to mention that in some cases, a narrow definition may be exactly what you want, because there could be a piece of prior art that would otherwise invalidate the claim. And if you have a narrower definition, you could survive that. I mean, the patentee, could be able to argue that the claim is patentable over this piece of prior art. So it's a very difficult thing in a sense, because you don't know what the future holds. On the one hand, you want a broad definition for infringement, but in some cases, a narrow definition may be very helpful in view of prior art. So I don't know, Joe and Reza, what you guys think.
In those cases, Reza, if you do that, wouldn't you include maybe some leeway by including terms like in some embodiments, except as otherwise mentioned, or that deduce from the context? So you try to leave some room while you're providing the narrower definition.
Yeah, in general,
which actually was the case here. I'm sorry, which was actually the case here. They said except as otherwise, but then the court argued you never used that limitation anyway.
You never said what otherwise is here. But I think in general, really we go back to the idea of you need claims of different scope in a sense.
Exactly.
That ultimately is the issue.
Exactly.
This is and I'll touch on something you said there, Reza. The effective filing date of this patent was December 7th, 2011. So that's 10 years before all this came up. And as patent
Yeah.
prosecutors, we always have in the back of our mind, really, there's two things. Number one, you have to draft the specification and claims in such a way that you can get the patent issue. Otherwise, you don't really have much. And then you kind of have to think about, okay, 10 years from now, we're going to try to capture a potential infringer's product, or, we're going to have to survive art we don't know about that is cited at us later, all these things. And it's really, it's kind of difficult. It's a difficult row to hoe, I guess I could say it that way. And, there's a push and a pull between, as we discussed previously in other videos, written description enablement, and then this decision. So I guess this decision makes me think, or, I'll just throw it out there. Should we include definitions in the specification? Would it have been better to leave out the entire definition section and just allow the litigators to pull down, treatises and, not
So you
case,
rely,
yeah,
you rely on the
rely on the state of the art.
state of art.
And
Yeah.
just at least we can argue, because right now it seemed like the litigator's hands are tied. You're like, well, we said 3 specifically, but then we said otherwise, not otherwise, or could be otherwise specified, and you're going to find some kind of textbook. Maybe you'd be better off if you could just rely on a textbook as opposed to being, sort of constrained by the definition that you set forth in the specification. But then you're up against the enablement written description issue. So it's a really, really difficult to thread this needle, I think.
I agree, but one of the things that this makes me think about is that whatever definition you provide, it better cover all the embodiments that you have in the specification. So I think that's one thing that I think you need to be careful about, that you're not leaving out certain embodiments out of the scope of the
Reza, was there the case that here, although you mentioned, I remember something too, were there any embodiments?
Apparently there were some embodiments that
Because they mentioned it, yeah. So that's certainly a big, but in general, what do you two think about having a separate section name definition? I usually don't do it. I avoid that. If I need a definition, I would bring it the right place and always leave that room.
Well, sometimes
having a separate section.
Sometimes I think it's useful to have definitions, especially, if you look at the biotech applications, there are pages and pages of definitions typically.
Yeah.
But on the other hand, you always have this push and pull, because sometimes, as I said, the definitions may come to rescue if you're up against some piece of prior art. And there are cases actually, and maybe we do a video on those, that it went the other way, that the definition was too broad.
Sure.
So I think it's really, to me, it's a case by case kind of decision to be made.
And it's always that issue that Joe mentioned, that having the crystal ball,
right,
which is never perfect, but you try your best to think about what could come up.
I've lost count how many times I've seen an examiner argue that definitions from the specification are not read into the claims. You'll argue, well, the claim means this, the claim term means this, we define it in the specification. The examiner said, well, then you got to put that definition in there.
Wow.
And so
does that carry the day in general?
If you want your patent issue, you better put it in the.
And you don't want to appeal it.
You take it up on appeal if you want.
Let me give you an example. You could say a textured surface.
Right.
And the examiner could come back and say any surface at some level is textured. Nothing is perfectly flat.
Right.
And this was a case I was dealing with. Unfortunately, we had a definition that what is textured means, what is the root mean deviation of the corrugation on the surface. And that was extremely helpful. Otherwise, by just saying a textured surface, the examiner would say, well, at low enough at high enough resolution.
Molecular resolution, yeah.
So I think this is where the definition was actually crucial to to getting the claim allowed.
Yes.
I will say that I do include a lot of definitions, and I think when I draft them, I do keep in mind that I want to keep them broad. I tend to throw the kitchen sink, and I'll throw a lot of different embodiments and a lot of different language in there, a lot of for example language, a lot of exemplary embodiments, things like that, to try to give yourself room to maneuver not only during prosecution, but litigation counsel later on, give them some room to maneuver as well, hopefully. But it takes added time. It takes, as you said, Reza, a crystal ball sometimes to think how this can play out, 10 years from now. And it can be really difficult. It can be a challenge, it's a good challenge, but yeah, I think this does not sway me to take out the definition part of the specification as I draft them, but I think it does highlight the fact to keep in mind, keep them broad, keep the definitions broad enough that you can get your patent issue, but still have the ability to kind of capture competitor products down the road. So,
which one way of doing it is what I think Reza mentioned. Try to do a lot of those limitations or specific definitions, put them in the claims or in the background section, not background, in the summary section, which could come from the claims, to have it covered in the original application. Which actually, I want to mention something else about this case. It's a side matter, but it was interesting because Alnylam also used another argument based on one of the dependent claims, claim 14, in one of the applications, or maybe both of them. And in that claim, I just was looking for the quote for the wording in the opinion. I had found it also in the, yes, the claim essentially says, further requires that the branched alkyl group has only one carbon atom, which is bound to 3 other carbon atoms. So they try to use this, and I guess the doctrine in some sense is called claim differentiation, right? Mm-hmm. They said if claim 14, it says only one that is bound to 3 other carbons, claim 14 says it, so claim 1 should be broader. This didn't work because in the court brought up that in the file history, essentially, this limitation was used to distinguish a different thing. That is an art which has multiple carbons bound, essentially the so-called tertiary carbons. And they said, no, as claim 14 is different because it only has 1. Mm-hmm. So that was limiting the number that are tertiary, not that there could also be secondary ones. So that's an interesting point that came up. And another doctrine was used there.
Mm-hmm.
I mean, I think ultimately the issue was that they were very, very definitive in the way they
defined
the branch alkyl term. So the other arguments were very difficult, to be persuasive because they had essentially boxed themselves in to having these at least 3 carbons. And
again, that's related to what both of you mentioned. And I guess it's also, again, about the hindsight. The question is, even when you provide definitions, which I do, but not very carefully about where it's really needed, you have to ask yourself, do I need to define this term? Or is it well known in the art? And I'm not going to limit it. I want to keep that definition, broad definition. Why did they decide to include this in the list if, as Reza said, some of their embodiments were outside this narrow definition, and they didn't seem to need it in their application, that narrow. Why did they narrow the scientific definition? Again, maybe they had something in the back of their mind, but nothing jumps out of the file history and the patent itself. So that was my point. Even when we provide definitions, we have to have a reason in cases like there's ambiguity. Reza mentioned about the rough surfaces or stuff like that. What do you think?
I don't know why, but I think during the litigation, it became clear that what they would have liked it to be is sort of an indication of some embodiments having this feature, not every possible embodiment. So um, they could have
But
maybe been successful at that if, as Federal Circuit said, it wasn't clearly within the definition section. It didn't have all these other sort of indicators that it's really, really a way that the patentee wanted to define the term. So I'm not sure exactly the reasoning why initially it was done, but I think, as Joe said, this was written more than 10 years before, and who knows? I mean, what they were thinking at the time and what they were up against.
Great.
But it's an
Well,
interesting case. Yeah.
it's a good
it was an
discussion.
interesting case.
Yeah, it's a great case, good discussion, and yeah, hopefully people like it. If anybody had any questions about it, get in touch with us. We'd be happy to, if you reach out by email or anything like that, we'll be in touch. So, well, thanks so much. Great
Thank you.
topic, and it was
Bye-bye.
good speaking with you.